Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson. I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the question or chat box and they'll be brought up at the end. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Thank you, Lisa. Welcome, everyone. Good morning, good afternoon. Welcome to The New Normal, your go-to source for insightful discussions on the gaming industry and critical issues affecting Native American tribes across the United States. I'm Victor Rocha. My co-host is Jason Giles, Executive Director of the Indian Gaming Association. In today's webinar, we're talking to our friend Joseph Webster, partner at Hobbs Straus and lead attorney in the landmark West Flagler case. We're talking about the hub and spoke model, its role in tribal gaming and sports betting and beyond. Good morning, Joe. Welcome.
Yeah, good morning, Victor and Jason. Thanks for having me today.
It's great to have you. It's great having you here, man. Good morning, Jason. How you doing, man?
Good. You know, I'm glad we were able to get Joe on. Joe's a proud Army veteran. Are you still in the reserves? Are you still hanging your neck out there for another recall and deployment?
Yeah, Jason, no, I got out a few years ago, but yeah, I spent a number of years in the Army Reserve.
Yeah. Wow. So to Iraq a couple times, right? Yeah.
Just twice.
So Jason, I heard there's a big protest outside your office for the hub and spoke model. Is that true?
Yeah, exactly.
Is that what they're protesting?
Right. They want it now. They want Delaware, Maryland, Virginia, everybody on the hub and spoke.
It's good to see people getting on the street and exercising their right, you know, to have choice and stuff like that. They should. I think that's what they mean for freedom of choice, is to choose whether they can do online gaming, you know what I mean, or not. That's the way the discussion's coming. You know, Joe, first of all, I mean, seriously, welcome so much. You know, everyone wants to know, especially in the industry, you know, the West Flagler case. I guess, you know,
dead?
everyone here would know.
Is it finally dead, Joe? I mean,
is it dead, Joe?
I mean, can we beat
Friday the 13th, or which one was the one with the lake? I should have worn my hat.
Some other court that they could possibly try to appeal this up to.
Yeah, well, I'll start, I guess with just the usual housekeeping that, of course, my comments today are on my own behalf. I'm not speaking on behalf of the Seminole tribe or anyone else. But yeah, at this point, the litigation is over. There are no pending legal challenges. The federal case, actually cases, I think at one point there were 3 different federal cases that were filed. One was a federal court in Florida, and then 2 were federal court in DC. And all of those cases have concluded. And then there was a state court case that was filed in the Florida Supreme Court, and that case was dismissed as well.
Excellent. I mean, and unfortunately, the Seminoles found themselves in a situation having to relitigate this over and over. And they were really in a unique position because we're not finding too many governors willing to work with their tribes the way DeSantis was willing to work and sit down with the Seminole tribe. And then here we are, potentially have a new model of cooperation and respect of sovereignty. And, we got this ridiculous lawsuit over and over that, tens of millions of dollars, unfortunately. How did they approach this? What was the strategy here? Because you guys really did a good job of keeping your head down and just sticking to the law and the facts and not making it a public relations. Which, by the way, you have a governor that is very good at PR, getting what he wants, taking on Disney and everyone else. How were you guys able to navigate this?
Well, I'll say one of the things that I always thought was a real strength of the case, in addition to the law, was the fact that you had all 3 sovereigns on the same side. So this was not just, the tribe's position. It wasn't just the federal position. You had, the state government, federal government, tribal government, all, essentially in lockstep, that this was permitted as a matter of federal law. So I think that was really helpful. Also, I think it's important to remember too in Florida that, certainly it was great support from the governor. In addition, when the compact was ratified and the implementing state law was adopted, that was done with overwhelming bipartisan majorities in the Florida House and Senate. So I think, those components, really were, important in terms of the overall success.
And I think that's what makes it so unique. I think everyone that's looking at Hub and Spoke, I mean, you have to look at the cooperation that there was to get that thing across the finish line. The fact that the Seminoles had that cooperation with the DOI, with the governor, it was just really kind of quite amazing. It's such a clean sweep, but it shows a path forward, a very complicated path. I think for a lot of tribes, California, it's going to be very difficult. I think right now on my research, we have Kansas in the batter's box, and I think everyone in Minnesota right now is looking at it also. But I think, what's interesting to me is that it's really struck fear in the hearts of the industry. They're saying, wow, we don't have the tribes where we had them before. It was a real effort by the Biden administration and Secretary Holland to really help the tribes and look forward for a path for online gaming. How difficult was that? Well, first of all, I'd like to say, and by the way, all the time I met you when this was going on, you were always very optimistic. You never any hand wringing. You always tell me, look, it's going to go. I have a lot of faith in this case. And just kind of what you just said, everyone was kind of all the ducks were in a row before you guys went forward. So, your optimism was a source of my strength. You know what I mean? I was like, well, if Joe said it, then I believe it, type of thing. But, it's not going to be as easy in other states, is it?
No, I think, that's one, important factor is that it is going to vary state by state. Some place, this is a tool that's available to tribes. It's an option. Some places, I think actually this could work very well. Some places probably not. And in other states, there may be ways to basically modify the approach. This is not a cookie cutter. I mean, the hub and spoke idea is one that I think it's sort of a starting point, but there's ways that it could be modified to address local circumstances, local political realities. So as you say, Victor, it's not going to be easy in a lot of states, but again, this is one additional tool that's available to tribes to consider. And also, you want to mention,
go ahead.
We're going on just to give a recognition to IGA for filing the amicus brief in the DC Circuit in support of the tribe and the compact. That was certainly very much appreciated.
No,
That was my idea.
Yeah. We do what little we can. I was a litigator for a very short time. Danielle, our deputy executive director, was a litigator for a very short time. So we understand that the litigating is where the hard work really gets done. Our role as lobbyists, we always just hover 10,000 feet above. But, so that's why we love having you on, and Scott Crowell and the people out in the trenches there really, that's where sovereignty is defended. And one of the things, Joe, I won't get too political, but this Supreme Court, a lot of the stuff that Kavanaugh was saying, in a Supreme Court rejection of a petition, I've just never seen so much commentary, which are almost like breadcrumbs. And, even in a concurring opinion, you had Thomas putting stuff in there, a one-liner about special prosecutors. And then lo and behold, Judge Eileen Cannon down in your guys' Seminoles area is throwing out the special prosecutor power. That has to be frustrating to deal with. I just don't remember a Supreme Court putting commentary in rejection of petitions. And when they're very specific about you shouldn't take away anything from us rejecting a petition. And that was something we dealt with, Victor, when they rejected the petition. You had analysts and everybody saying, Seminoles won, that the law is this now and that. And, it's like, slow down. The law is not this. It just means they're not going to hear the case. How did you deal with that, Joe?
Yeah, no, I agree. I mean, I think it's certainly, we were all glad to see cert denied. The fact that only one justice would have granted cert, I think was helpful. But you're right. I mean, you can't really take too much from that in terms of the that being a decision on the merits. It's not. but you're also right too. Not just in this case. I think in general, I feel like we've seen more of these sorts of commentaries with orders denying cert that maybe you wouldn't have seen before.
And even, standing issues, these the prudential concerns, the things you learn in your first year of law school, boy, they seem to overlook a lot of the standing issues now, even, and I'm glad that, your law firm has, been out there supporting Indian country for a long time. And we're just glad that we're happy to help anytime on Amicus. That's really what we're here for, is when you need another voice, when you need another perspective to give to a judge, that's what we're here for. So I will say, last time we spoke about hub and spoke, I'm not sure, Victor, that, we gave a good, like, what is your definition of a hub and spoke, Joe? Even if it just as it relates to Florida, how's it going to work in Florida?
Yeah, it's funny you mentioned that, because I've actually heard it described different ways by different people, and not necessarily the way that I've thought of it. Certainly the way that I've considered hub and spoke is it's a way to use both federal law and state law together, where you have the server that is receiving and processing the wagers located on Indian lands, and which is the hub, and then the spokes are the devices that are being used to transmit the wagers to that server that may be located off Indian lands. So to me, that's kind of in very basic terms, the hub and spoke. I know that some people have also focused on the fact that under the compact, there's a role for the parimutuels in Florida, where they're able to act as marketing affiliates, and that those might also be considered spokes, which, I think maybe is also, it's sort of the same thing, but in terms of that's where the wagers are placed, but they ultimately are received and processed on the tribe's Indian lands.
Now, Joe, that's an argument and that some of the offshore operators were making back in the 90s and early 2000s, in international courts and stuff, like, hey, the server's over here in, Grenada, and we're just taking bets from the American customers, but the actual bet is being placed, down here in the Caribbean or wherever else. I mean, is that an extension of that argument, or what? Is there a difference?
I think the difference, and it's actually the difference compared to what happened in the San Isabel Desert Rose case, that in Desert Rose, and as well as the offshore situations, you have operators that are asserting unilaterally that they can deem the wager to occur where received. The difference here is you have the jurisdiction where the bettors are located also agreeing that it's legal to make those wagers, and as a matter of state law, deeming the transactions to occur where received. So I think it makes it a much different legal situation, and frankly, that's why, from our perspective, we never saw this as being in conflict with any of the other cases out there. This is, to me, the answer to the shortcoming that the Ninth Circuit found in Desert Rose, that the placement of the wager was illegal where the player was located. That by making it clear that as a matter of state law, the wager is legal, you avoid then the potential issues with UEJA and otherwise.
Mm-hmm. Right. I mean, essentially, in Florida, then, how is it that you arrived? I mean, was that the tribe's initiative? Was it, a state initiative? How did they agree to this kind of model?
Well, I think it was certainly collectively trying to come up with an approach that would provide the tribe with something of value. Remember that under the 2010 compact, there had been a violation of the state's exclusivity. And after giving some time for that to be cured, and it wasn't cured, the tribe was no longer making payments to the state. So part of the framework was, if the tribe was going to resume payments, there had to be something that would justify that value. And, candidly, adding, a few games at the brick and mortar facilities really wouldn't do it. It was trying to come up with, is there, something, more, and looking at mobile gaming, made a lot more sense. And in that context, it was then looking at what does IGRA allow? And this is where you can talk about, one, the allocation of jurisdiction provisions that are found in IGRA that allow a tribe and a state to reach agreements with respect to how a wager is being regulated, as well as looking at the lessons from Bay Mills, from Desert Rose, and some of the NIGC opinions over the years to say, if you are going to do this, it essentially is a hybrid approach. You've got to be able to show that the wager is legal where it's placed and where it's received. How do you accomplish that? And then once you have those two pieces together, to then use the compact mechanism for deeming the transaction to occur where received, so that it's all regulated under the compact. So it was really kind of a multi-step legal process to get there, but the end result is, of course, the hub and spoke model.
And
And real quick-
go ahead, Jason. Go ahead.
Well, just since you brought it up-
go.
we're usually better at this, Joe.
Yeah.
Well, since you brought it up, just real quick, I want to skip ahead then. Since you said some of the federal regulations, do the most recent Department of Interior regulatory updates, is it going to make it easier for tribes and states to move on this model in other jurisdictions? How did those play a role?
Yeah, I think so. Now, obviously those regulations were adopted after the Seminole Compact was approved and the litigation was ongoing, but the approach that Interior uses in the 293 regulations is certainly consistent with the approach that's in the Seminole Compact. So I think, were there to be a challenge to the 293 regulations, the West Flagler case is powerful precedent that those regulations are in fact valid. So I think the regulations certainly then give national import to this. So I think yes, absolutely, those regulations are helpful in this area and a lot of other areas as well.
Go ahead, Victor.
Yeah, it seems like everyone is focusing on the fact where the server is, but it seems that from a layman's point of view, it seems like one of the bigger issues here is the fact that these compacts can be negotiated between the tribes and the governors and the DOI. And as long as sports betting is illegal in the state, then they can go forward with it. The big issue you have in California right now is that sports betting is not legal. So the hub and spoke doesn't really matter because, like in Desert Rose, that was kind of the case, was the fact that sports betting wasn't legal in California. So it seems to me that it just really opens up a whole bunch of other avenues besides sports betting that says, look, at these negotiations are illegal, and just because you don't like them doesn't mean they're illegal, right?
Yeah, I mean, I think it's right. It's not limited to sports betting. It's, any sort of gaming that's permitted by IGRA, you in theory could have an arrangement with the state as long as those wagers are permitted as a matter of state law that they could be included in a compact. But you're right, in terms of California, it's, you would need to have both parts there. You would need to have a compact and the conforming change in state law.
Do you think there's going to be, and it doesn't seem, as soon as this was done, you look at Arizona, Arizona's going forward with 2 more sports betting compacts. You don't see them backtracking and saying, maybe we made a mistake with the tribes and sovereignty. Maybe we should look at this again. So it really is about going forward and negotiating, right?
I think so. And, I've certainly heard from some of the tribes in jurisdictions like Arizona that, that basically that model has not worked out very well for tribes. We're tribes are only getting a relatively small fraction of the revenue, and not even all the tribes are able to participate. Going backwards, I think when you get other commercial entities involved, it's hard for me to see how that happens. I mean, it'd be nice if the situation could be improved for tribes over time, but I think at least right now you're right, Victor. It's probably going forward looking at states where there is not an existing framework in place.
Let me just we'll put the boring legal stuff to bed after this question, Joe. But remember when the case first went to district court, the tribe in Florida lost that opinion to that district court judge. And do you think that given maybe just a slightly different set of facts in another state, that there's some things in that first district court opinion that could still prove problematic, because I think it was a female district court judge. I think she was trying to say, piercing the veil a little bit, like, the state and the tribe can't make up their own sort of jurisdictional laws, if you will. And I only bring this up in the context of, we're going to have other challenges. Hub and spoke is not a good model, I don't think, for DraftKings and FanDuel and some of these commercial operators. And they're, maybe they could bring other lawsuits in other jurisdictions if other states and tribes try to adopt this Florida and Seminole model.
Yeah,
Is there anything lingering that scares you from that first district opinion?
Not really, because I think it was really, based on a misunderstanding of what the parties were trying to accomplish. If you look at the decision, it really relies on a view that the compact itself was attempting to authorize the off-reservation aspect of the gaming. And that was certainly not the position of the state or the tribe. The position had been that that's why we had the separate state law that was adopted at the same time as the compact was ratified, because there was an understanding from the beginning that you needed both pieces. And I think the district court, unfortunately took the view that it was the compact itself that was authorizing it. That's where, the DC Circuit in their opening, I think, said, very strongly, they talk about what the district court said, and the DC Circuit said, we see the case differently. And that then led, frankly, to the rest of the analysis. So it's how you look at the language of the compact. What was the compact doing? Was the compact authorizing off-reservation gaming, or was it including basically discussing the off-reservation aspect because it's directly related to the gaming that's occurring on Indian lands, and the off-reservation is authorized by state law? So it was really that distinction that I think it wasn't recognized.
No, excellent point. Victor, we can go on to the more national implications, which is what I think a lot of people on the call want to hear today. I mean, we don't need to delve into Kansas, although, but if you look at a place like Kansas that has state-owned gaming, I feel like Hub and Spoke would be perfect for them. But let's take a jurisdiction, since someone asked about, a jurisdiction where a tribe doesn't have to deal with the NIGC or the state. The only one I can think of is Mississippi Choctaw. If Mississippi Choctaw wanted to do something like that, that'd be quite a hurdle, right? You're operating there. You don't have a state tribal compact. You're free from NIGC regulation. You're going to have to go out and compete to set up a model like that.
It helps if you have a governor that wants to be president.
Is that what it comes down to? Well, there you go, California. I mean, Kamala's beating him to the punch, but geez,
Oh, he's out to pasture for another 8 years.
Man.
He still looks young. He'll look distinguished with that gray hair on the side by the time he gets up there.
All right, he'd stay out of the sun so he can keep his youthful good look.
Keep your teeth. Keep your teeth. That's my advice.
But Joe, I mean, what do you think of? We don't need to do a state by state, but it is. I feel like if somebody like Governor Stitt in Oklahoma talked to Ron DeSantis and said, "Look, this is going to benefit the state of Florida immensely."
Right. I think and I obviously don't know the views of the tribal leaders in Oklahoma, but this sort of model could work in a state like Oklahoma, where frankly the gaming is where the tribes do have the political influence they do, and frankly the expertise that they've built and developed over so many years, that at least in a framework, I think it could work. I mean, there's different ways the hub and spoke model could be used in different states, and particularly states where you have multiple tribes. Again, in Florida, the servers are on the tribe's Indian lands. There is a requirement in the compact for the tribe to have agreements with the parimutuels where they're paid a percentage of revenue to provide marketing services. there's no reason that you couldn't do something similar between tribes. If you had, some tribes that didn't want to have their own platform, that wanted to participate, but didn't necessarily want the risk and expense, you could have, some tribes that would have platforms and other tribes that would have, essentially affiliate type arrangements with those tribes. I mean, again, to me, that's one of the things that's really nice about this approach is there's a lot of flexibility in terms of coming up with something that works in different state circumstances. Oh, Jason, you're on mute.
Sorry about that. Taking that one step further, I mean, we just had a question and I was thinking along these lines. If you're a tribe that doesn't have a gaming compact, but is heavily invested in Class 2, do you feel maybe there's other avenues for a purely Class 2 operation to branch out in this manner?
Yeah,
Sorry, I didn't understand.
I think, there's a couple of one, if you have a state where you have tribes with both Class 2 and Class 3, it certainly would be possible, I would say, for a tribe, with Class 2 to have a marketing type arrangement with a tribe that's operating a platform. Is there a way to extend this, to Class 2? I think, again, it's sort of looking back at Desert Rose, and, you have to answer the question, is the activity permitted where the wager is placed? If you're able to answer yes, then I think there's at least some ideas about how you could structure a hybrid approach that would involve both the tribes regulation of the gaming under its gaming ordinance and a state authorization for the placement of the wager.
So as of right now, I saw Florida has immense environmental challenges. And I just saw a note, they're going to try all this flood control relief and everything. And DeSantis mentioned in there the amount of money that they expect to receive from the Seminole compact, particularly sports betting, and that a large amount of that money is going to be earmarked for flood control, in down south there. What is that's kind of what we want to sell nationally when you get these kind of partnerships, and how it's a win-win for not just the tribe, but also the surrounding neighbors, and how much it can contribute to a state's infrastructure, to the betterment of the state citizens. How much of that is, Seminole getting out in front and really pushing this? And because Seminole's kind of reached that level where they're so associated with the Hard Rock brand now, Joe, they're almost looked at as a corporate entity. And we know that they're one of the most traditional tribes in America. A lot of the people on the reservation still speak their language. If you've ever dealt with the Seminoles, that at 5 o'clock, if you're not a Seminole tribal citizen, if you're not married to a Seminole tribal citizen, you got to get off the reservation by the end of the day each day. They don't put up with a lot down there, and they fight hard for their sovereignty and their jurisdiction. But I mean, they've really shown how to partner with a state. How much of that goodwill is part of this?
Well, I think it's certainly a testament to what the tribe has achieved over the years, and been able to build this partnership with the state. I mean, I've had the privilege of representing the tribe now for, something like 30 years. And I certainly remember as a young attorney, being involved in some litigation, and there was litigation between, the tribe versus the state versus the tribe, feds versus the tribe, feds versus the state. I mean, it was just a very different environment, and to look at where it's at now, it's really pretty remarkable. And to your point about the use of the proceeds, my understanding is exactly that. It's actually, I think, the vast majority of the money that the tribe is paying the state in terms of exclusivity fees is being used for environmental projects. So, again, I think that, just from a personal standpoint, that's seems like a really good outcome.
Mm-hmm. Seminoles hit all the right notes. They don't get enough credit. this is a bigger issue in the DC area, but about, using Indian mascots for names in high schools and everything. And, what do the Seminoles do? They work out an arrangement with Florida State University. And, that was part of that was the NCAA required colleges to do that. But, there again, Seminoles get a lot of recognition whenever Florida State is, playing in national championship games and the whole 9 yards, and you see Seminole Hard Rock Stadium. It really is amazing, Joe. But I will say there's a bunch of states that are going to have new compacts that are going to have to be renegotiated, Oklahoma being one. What can we recommend? What would you recommend that they start off with in terms of hub and spoke model, and what's the new technology and the new way of looking at how bets are placed? How does that translate into compact language, or even just compact principles?
Right. I think it's a few things, and some of these are, true, whether it's, mobile gaming or whether it's brick and mortar, but, obviously to understand the market, to make sure that, the tribes understand what they're buying in terms of exclusivity. Are they buying exclusivity? If not, does it make sense? What does the competitive landscape look like? If you already have, substantial commercial interests that are offering mobile gaming, where does this fit in? How does this fit in? So I think it's doing the market studies and the due diligence on the front end to make sure that there's a clear understanding of what the opportunity is, and then to figure out if you're able to develop compact language that meets that. I would say, just from a drafting standpoint, it's important to make sure that you have all the pieces. That the compact is important, but make sure you've got the appropriate state law language drafted. Make sure that it complies with any state constitutional limitations, because they really are essential that you have both together, because they both work together. And then in addition to that, it's the moving to the implementation phase. It's all the regulations, all the policies and procedures, everything that the tribal regulator is going to need to have in place to be able to make this work. And so it's a fairly daunting undertaking. So it's building in the time to make sure that you're able to accomplish all those tasks.
That is something real quick, Joe. How has the regulatory side of this, the Seminoles been handling it? The Seminole Tribal Gaming Commission. There's not a lot of expertise out there of people who have operated under this model for a long time. How are they approaching this?
Well, I think the Tribes Gaming Commission, frankly, they've got a first-rate gaming commission, and they've developed and brought in a lot of expertise, and we're able to build obviously they weren't starting from scratch, with the scale of the operations that they had. It was being able to put in place what was needed for mobile gaming. But I guess my point is that that's a critical part of all of this in terms of making it work, is to get those regulations right. And then certainly in Florida, then there's a good relationship as well between the tribal regulators and the state regulator that has an oversight role.
Mm-hmm. Great. Victor, you want to hit some of these questions? I mean,
yeah, let's go.
I will say, let me on California, what Joe just said, at least some of the compacts I've read in California, Victor, they have really broad, even broader than what IGRA allows for in terms of technologic aids. California had a catch-all provision in a lot of theirs, like, any future technology is, sole province of the tribe, et cetera, et cetera. Really, California is set up, once they get the constitutional questions set, hub and spoke, that could be game over for the
but look at you still have to change you still have to change the state constitution. You still have to go to the people. So everything still goes to that. Nothing has really changed in the fact that you still have to have and it kind of goes to Ernest Matthews' question. You have to have a cooperation between the states, the feds, and the tribes to get this done. I think any one of those legs out of the stool, excuse the cliche, is going to make it really difficult. I don't think you can just ram it down the throat of the state government and stuff like that. I think there really has to be negotiated, but it's a path forward. I think it's going to be easier for Kansas or Minnesota than it is for California. I think California is just I'm still wrapping my mind around it. I mean, it could be easy. It depends on the cooperation. If the tribes are all on the same page, it could be nice and smooth and easy standing in front of the tribes with the governor and and the Department of Interior saying, we approve on this, and the people of California have done properly. But there's a lot of moving parts to that still.
Well, we wanted to and Joe, you're not the expert on every state, but it seems like the attendees they want to know how this is applicable in their state. I mean, Gene Johnson asked, if Florida were to legalize iGaming, what modifications would have to be made? I mean, that's the Seminoles would be giving up some exclusivity if Florida legalized iGaming, right?
Yeah, I mean, so iGaming is addressed in the compact in terms of that would be an expansion. I guess there would certainly be changes that would be required in the compact as well.
Yeah, that one's hard to see. I don't know why they've got a good system now. Although, iGaming, it's been wanting to take off for a while, and I know it's popular in a certain subset, and there's certainly money to be made there. I don't think you can overlook it. It's going to keep getting bigger and bigger. Every new release of these, whether it's Call of Duty and all these kind of things are, I can't believe the interest it generates. But, the other one, Joe, real quick, we might have some knowledge on this one, but what happened in New York, and specifically Western New York with the Seneca Nation? New York's got these, sphere of influences. The state did legalize gambling in certain areas, but it has to stay out of a tribe's zone, a certain radius. Hub and spoke actually might be good for the New York tribes if they could coordinate and get a governor willing to work with them. What do you think of the way it is in New York right now?
Yeah, so we do represent Seneca, so I won't comment specifically on that. Okay. I'll maybe pull it back out to the 30,000 foot level. That I think in any jurisdiction, again, you have to look at what the tribe or nation is actually paying for, and what is exclusivity. How valuable is it? How much exclusivity does the state have to sell? And when you're talking about a state where there's already significant brick and mortar competition, if iGaming is going to be available, then in order for the tribe to pay for it or be able to make those exclusivity payments, there's got to be something more than the tribe is just competing against a bunch of commercial entities.
Right. And, finally, Victor, the Oregon situation, Scott Crow was on here talking about the Oregon situation and the deal the Oregon lottery cut. As if other people enter the market, they get more and more of the money, the commercial.
Right. A suicide pill.
Right.
I will say I've never seen anything like that.
I know.
Extraordinary.
They must have a really good independent agency there it's almost like there's no state regulation of what the Oregon lottery can do and what contracts they can sign. I've never seen such a situation, but obviously the tribes up there are facing a different situation where the governor doesn't want any more expansion of gaming, and Hub and Spoke, I don't think they're anywhere near ready for that. But I think, again, it's important, and I brought it up again, some of these models, these commercial guys are not going to like them because it just sort of, it gives, in their mind, it gives too much power to the tribes to set the market. But, they weren't complaining in Kansas and some other state jurisdictions having to go into those states and deal with them. And now you've got states looking to hike up the tax rate on them. So, I don't know where this goes because the animosity between commercial gaming and tribal gaming was something we've seen before in the 90s and early 2000s. We thought we had largely moved past it, mostly because we have so many mutual interests and the exchanging of regulatory personnel, and everybody's working for safe gambling throughout this country. But we're seeing it again creeping up, whether it's Maverick, West Flagler. Is this, Joe? I just don't know why it would be a source of friction moving forward with the commercial guys, other than they feel like they're not going to have an opportunity to compete, which I think is just the opposite. They need to get in and engage with tribes the same way you got in and engaged with the state of Maryland, state of Pennsylvania, state of West Virginia. What do you think about that?
Yeah, I know, Jason, I think that's a really good point, because I do think that, as you said, we kind of went through that back in the 90s and early 2000s, where there was just this strong opposition to tribal gaming by the commercial interest. And then I think, by and large, they realized that there was an opportunity to work together in common interest. I think it's probably the same thing here, that, ultimately the hub and spoke model doesn't preclude the involvement of commercial operators. It's figuring out, kind of how that works in each jurisdiction, and each jurisdiction may be a little bit different, but I think there's a lot of synergy and a lot of ways that, frankly, tribes are going to want and need to bring in some of the expertise that those operators have. So to me, I think it's a matter of perspective, and hopefully, that will evolve over time, where there'll be a recognition that, this is something that really can work for everybody.
I feel that, one of the most important things about the West Flagler was that, before West Flagler, the tribes had their feet nailed to the ground because of IGRA. And this was an industry, commercial and sports betting, that was not stopping to wait for the tribes. And, West Flagler gave the tribes that bit of oxygen they needed to go forward. So, it's such a big deal. You know what I mean? It's such a big deal. And the sports betting companies weren't waiting. You see, the SBA was being very aggressive. Obviously, DraftKings in Oregon, look at what they did in Michigan, look at Arizona, where they divide and conquer the tribes. So I think they see that, and you can see in some of these analyst notes, Santarelli from Deutsche Bank talking about, the tribes can go get a compact where they'll get 60% of the revenue instead of 12%, 10%, 8%, whatever they're getting before. So I think the sports betting industry knows it's a threat, existential threat. I don't think so. They're still going to make money. You know what I mean? But for the tribes, it gives them the oxygen they needed, to fight this fight. And, I think a lot of the industry was excited when Desert Rose happened, and they felt, okay, good, we cut the tribes' legs off. They won't be able to fly. But here they are, here we are, we're talking about sports betting, and online gaming is the next step. So it'd be interesting to see how it plays out in California. I just know that it gives us optimism here in California. And I think everyone's really excited about that. I think we have a governor that understands tribal gaming and has good relationships with the tribes. We have great leadership in the state, and the only issue I see is 105 tribes and 60 something casinos. But other than that, easy peasy, So we do have some comments here. Hey, Ryan, how you doing, buddy? Let's go. So Ernest, I think we answered your first one, which is, as a general point, is it true that there will always need to be a positive legal approval, state legislation, or compact negotiation inclusion that the betting offsite of a tribal jurisdiction where the server is located needs to occur? I know I messed that up, but the answer is, yeah, basically kind of what we're saying. There needs to be cooperation between all parties going forward. One of those, without the state, without the DOI, without the tribes, you don't have a deal. So I think it just shows that, I think it's going to, I think in Oregon, in Oklahoma, it just shows it's going to be a little tougher for those guys without a good relationship with the governor, because you can't go around him, right? As far as I know, right, Jason?
No. Yeah.
He's
controlling everything, even though his own legislature and attorney general are generally opposed to the way he's dealing with tribes.
Right.
Yeah.
Blue Kui, hey, it's going, brother. What about daily fantasy sports? Now, this is an interesting one. Now, in California, you had and a lot of the industry has a real problem with daily fantasy sports because that's what gave birth to FanDuel and DraftKings. And I think a lot of people are like, you know what, we're not going to get caught flat-footed again. Now, the guys in Prize Picks are going around California right now trying to talk to the tribes, saying, listen, don't shut that side door that we've been coming in. You know what I mean? But I think in California, the Attorney General is saying that's illegal. You guys can't come through the side door just because we haven't defined it doesn't mean it's not right. And I think you're going to see some of those pathways closed, I think. But for tribes going into daily fantasy sports, I don't know, Jason, what do you think?
The daily fantasy sports is a colossus waiting to move, as are in-game betting, all the ways that you can gamble much faster. And one of the things, Joe, I was going to ask you, again, on the regulatory side, we're starting to see more and more problem gambling stuff. Not cheating, but players betting on themselves. There was a receiver at LSU that had thousands and thousands of bets, which clearly he must have had a team of people betting for him. Hub and spoke, can that sort of tamper down some of that volume, or as long as we can see where it's coming from, right? It should still be a fine way to regulate and make gambling safe, right?
Yeah, I don't think that whether it's hub or spoke necessarily makes a difference. It's really a question of the quality of the regulations and the quality of the regulator,
right?
That's, keeping tabs on that. And I think so. Any jurisdiction, these are going to be important issues.
Yeah. I mean, Victor, it's all sort of packaged into one: iGaming, daily fantasy sports. It's all going to be there and be dealt with eventually here.
Well, look at I think the motto is, daily fantasy. We're not talking about daily fantasy sports. We're talking about sports betting. We're not talking about sports betting. We're talking about iGaming. So it's kind of the same thing. You know what I mean? It's all a pathway into something else. And daily fantasy sports is the gateway, the path, right? Gateway drug. Is that the word we're looking for? So I think a lot of people are very suspicious of it now, and especially now that FanDuel and DraftKings came and sucked the oxygen out of the room for the commercial gaming guys. I mean, look at New Jersey, look at those numbers, and there's just no denying that, as Lisa said, there's going to be a cannibalization issue with iGaming. So in a way, the slowdown in some of it, I know in California it's been very beneficial because you're seeing the blowback, the gaming addiction, all the sports betting. The conversation this past week has been about over at Nickel G's talking about the athletes being threatened. The week before that, it's about that too. So sports betting is eating itself. I think the longer it takes, I think the more it's going to be, you'll see more controls over it and stuff like that. But I think daily fantasy is a side door into the industry. And I think in California, we're talking about slamming that door shut. So, there's a lot there. Here's an interesting, Chris Siroti's talking about going back to Oregon. Basically, DraftKings structures a contract with the Oregon Lottery that keeps more of the revenue from sports betting should more competitors come into the market. Right now, they're the only ones offering wagering. How does this impact tribes in Oregon who may want to enter the sports betting market? Now, this is an interesting question because DraftKings has a gun at the head to the voters and the constituents, the residents of Oregon, I should say. You know what I mean? So if the tribes get sports betting, DraftKings gets 90%, 95%, just something outrageous, So I think stuff like that is bad for the industry. It just shows that these guys are desperate and don't really care about appearance, civility, laws, taxes, all that, addiction, and that's the way it plays. You know what I mean? So, Chris, I think the answer is, the tribes are behind the eight ball. This kind of, I think, with the government trying to negotiate these deals and knowing how much money they're going to lose, I think they're going to come at it a lot more cautiously unless they litigate it. But, I'm sure the SBA had a much better lawyer than the Oregon Attorney General.
I won't make you speculate, Joe, but there's restraint of trade. There's, all kinds.
He didn't flinch, by the way. All that he didn't flinch at any of that. Like he was going to answer one of them. Nice
Right.
poker face.
Exactly.
Nice poker face, man. Good job.
Litigators,
Good
what?
job.
Yeah, but litigators, they don't need to show anything until they get before a judge. So, but again, these are all sort of interrelated, Joe. And I will say, the iGaming, Victor, we've been hearing about the demise of brick and mortar as we get more and more internet gaming. And why would you go to a casino to play a slot machine if I can just do it at home on my big screen TV? Honestly, and Gene knows this, a lot of folks that have really looked at New Jersey, Delaware, their casinos are booming right now. The casino over here in Maryland, even though we've got sports betting only in Maryland online, I think, Joe, and Seminoles, I've never stepped in Seminole Hard Rock and, not been shoulder to shoulder with 1,000 people in a little 20-foot square area. It's so packed. I mean, I really think as long as you're stay up with the times and recognize what your customer base wants, I don't know that iGaming is going to in the end be the threat that it just from common sense. The malls, I don't know, the malls are going away though, and you can blame that on Amazon. So but
horse and buggy, man, horse and buggy. You know what I mean? All those horse sales, like I don't understand why all they're gonna do with those cars when we've been using horses all these time.
But I feel
but as younger people get older, you know what I mean? They're getting addicted to their mobile devices, and casinos prevent it. But if you look at what happened, go ahead.
A store like Ulta is surviving. Like people want to go into Ulta and get makeup and all that. And you can look at certain markets, and I think you just got to cater and stay on top of what your customer wants.
Isn't Ulta Dollar General with the Spanish accent?
No, Victor.
It isn't. It looks like it. So okay, let's go through these. Ryan, I can't pronounce your name correctly.
Yeah, this one Joe will know. Yeah.
Any commentary about the appeal of Maverick and the decision of the DC Court of Appeals? Sorry, it's right behind my camera. To deny the tribe's motion to dismiss under Rule 19 in the West Flaggers case. So how is that going to affect the Maverick? Which is a good question. Or can it? Or does it?
I don't think it really has much of an impact on Maverick. The DC Circuit upheld the district court's decision to deny the tribe's motion to intervene, to dismiss, but they were clear that they did so on different grounds. And basically they did it because they were reaching a result that upheld the compact, so it was not going to prejudice the tribe. So I don't think it really has any significant impact on what's happening in the Maverick gaming case. One thing I'll add, just because I think it is relevant to some of the cases like Maverick out there, there is some really good language on equal protection in the DC Circuit decision, and that's maybe gotten less attention. But the DC Circuit, in addition to addressing the IGRA issue, also addressed the arguments that this violated the Buyer Act, violated UEJA, and violated the Fifth Amendment Equal Protection Clause. And
I saw that. Yeah.
So I think that language is probably probably helpful.
Well, all the Twitter lawyers were just having a heart attack, because especially when they saw the equal protection clause in there, and what's his face is saying this is the path you were going to go, and then he gets shut out, with the decision. So it was all the Twitter lawyers were a flutter. They were a flutter, So see where are we at? Okay, we got Ryan.
Yeah, I think that's good, Victor. We got them all.
Yeah, sorry guys that we're gonna not get all of them, but you know what I mean. First of all, Joe, thank you so much. I mean, there's so much here. We can't wait for you to come back to finish part 2 of this conversation. We appreciate you coming. I mean, this is such a fluid issue, but it really helps define the tribes. I think, like I said earlier, it was from where I stand in my pachanga.net hat. You saw the government, the state government, and the tribes and the feds working together to find a solution to this problem that has been, killing Indian country. And, you know, it was incredible that the Seminoles had the nerve and the wherewithal to continue this, and they never flinched, and you never flinched. And like I said, you know, when we saw each other again at the coffee machines and stuff like that, I think you never flinched, brother. You were always believed in what you were doing. And, you know, I was always made me optimistic and allowed me to stick my neck up and said, you guys don't understand. I was talking to Joe, he said. And so we really appreciate it. That was great. I mean, how exciting was it? Did you go and have a dinner after the case was on? Is like, I'm a Supreme Court litigator and we won. What do you do? Do you get a plaque, like a YouTube plaque or something like that? Or does your firm send you chocolates? What happens?
You know, nothing like that, but certainly a nice celebration with my wife. And it was very gratifying to get to this point, and certainly an honor to be involved.
Brother, we can't do it without people like you, man. You know what I mean? We've always had incredible allies. And as you said, you know, you've been working for the tribe for over 30 years. What a journey, man. You know what I mean? What a journey. You know, the Seminoles have been providing guidance for years and years and years, you know, and how to do things. Don't flinch. Worst case scenario, run back into the swamps with your slot machines. You know what I mean? They've always had a plan B.
Right.
And very admirable. And thank you so much for being
Thanks,
the
Joe.
great ally that you are. And next time you talk to the tribes, tell them the rest of Indian country is in deep gratitude for them.
Right. And thank
to them.
you for your support for Indian Gaming Association. You come to our conferences all the time. You never hesitate to speak, and we enjoy having your perspective. So thank you so much, Joe.
Thank you
Yeah.
both very much. Really appreciate it.
All right, my friend. And everyone out there, thank you guys so much too. This has been a great conversation. We'll be here next week with Scott Crowell again, talking about the Chevron doctrine and what that means. Joe, you're more than welcome to come back.
Oh yeah, Joe.
We're going to be talking about Chevron. Everything we're talking about next week's going to negate what we talked about today. So don't you worry about that.
All those supposed expert bureaucrats. We're
gonna have all those. Yeah, exactly. So listen, everyone, thank you guys so much. We'll see you guys next week. Okay.
Great.
Thank you,
Take
Joe.
care. Bye, everyone.
Bye.
Bye.